You believe you suffered horrible injuries because your doctor did something wrong, that they were careless. And now you want to go ahead and file a complaint and put pressure on the doctor's insurance company to try and get them to settle this matter before you ever have to file a lawsuit. Can you do this? Will an attorney take this on? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. What you want to do is you want to bring a claim against the doctor's insurance company. The doctor has medical malpractice insurance for just this purpose. And you think in your own mind that you've got a great case. You think that the doctor was careless and violated the basic standards of medical care, causing you such terrible injury. And you think there's no possible way they can deny this claim. You come into the office and you say, listen, I don't want to bring a lawsuit. I don't want to go to trial. I want nothing to do with that. But I want to try and pressure the insurance company to go ahead and pay me for my claim. Will you take my matter? The answer is no, I will not. You want to know why not? Because in medical malpractice cases, especially in New York, the insurance companies don't roll over and play dead. They defend these cases to the bitter end. They will do everything possible to hire the best attorneys, the best medical experts, and they will fight us tooth and nail for 2 or 3 years during every single litigation to show to the doctor that they are behind them every step of the way, even if there are weaknesses in the doctor's case, even if they believe something was done wrong. They have an agenda, and their goal is to show, number one, they did nothing wrong. And if they did something wrong, hey, they're going to blame us, you, the client, the injured victim, for also contributing to your injuries. And then they're going to turn around and say, hey, wait a second, your injuries really are not as bad as you claim them to be. So even though you want all this money to compensate you, take a hike. We don't believe your injuries are worth as much. So that's what their goal is. And now you come into the office believing, hey, I'm going to put pressure on the insurance company and threaten to sue the doctor. And you think they're going to roll over and say, okay, we give up. The reality is, it doesn't work that way. So why won't I, as an attorney, take on a case like that? Because I am prohibited ethically from ever threatening to bring a lawsuit without having an intention to do so. If you tie my hands and say, hey, you can't bring a lawsuit, I don't want to participate in the lawsuit process, then I am not permitted to ever say in a letter, in any writing, in any documentation, hey, if you don't go ahead and resolve our claim now, we're going to bring a lawsuit and drag you through the litigation. You know what they say when they read that? Ha! They laugh. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil lawsuits involving medical malpractice here in the state of New York. You know, I realize you're watching this video because you have questions or concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit and you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. You know, I answer questions just like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.